I think it is, and you didn't need this decision, but I think it is beyond question that poor organisational justice or a lack of procedural fairness is a recognised form of psychosocial hazard. I think that's beyond question. And
The concept of psychosocial risk is far from new, but the dialogue and industry discussion about the topic has elevated since regulatory changes were announced in 2023 and 2024. Psychosocial risk is now the focus of many conversations in the corporate world, from boardrooms to executive teams, and of course through to the practitioners on the ground, trying to join the dots to have meaningful impact. I'm Kate Connors. I'm a master's qualified psychologist, and my professional purpose is to help people and workplaces be at their best.
And I'm Greg Smith. I'm a lawyer who's spent more than 30 years practicing in the areas of employment law and workplace health and safety. I'm also the author of several books, including Paper Safe and the recently published Proving Safety.
And you are listening to Judgmental, when a psychologist and a lawyer walk into a barside chat about psychosocial risk. A big thanks to our sponsor, EML. EML are Australia's largest personal injury claims provider, providing claims management services to workers' compensation, life insurance and CTP markets, with the purpose of helping people get their lives back. We have another jam-packed episode today, so grab a drink and sit back for another discussion at the bar. Hello, listeners, and welcome again through our virtual bar. It's Kate Connors, and I'm here with, as usual, Mr. Greg Smith. But before I hand over to Greg, I just wanted to acknowledge traditional custodians of the land that I am on today, and that is the lands of the Wiradjuri people of the Kulin Nation, because Greg and I are no longer in an actual bar together. How are you, Greg?
I'm very well, thanks, Kate. I'm on the lands today. I'm on the lands of the Whadjuk people of the Noongar Nation. I'm over in Perth. I'm on the other side of the country again, and doing it virtually instead of live. But it's good to be catching up again. It's been a little while.
I'd forgotten how to do this whole virtual catch-up thing. I was a bit useless a moment ago with trying to sort out my audio and stuff, wasn't I?
We're all back. We're all good. And so that was all good. And we've got a case that has really grabbed your attention, but we'll come to that in a moment. So what can I get you? What can I get you to drink?
I wanted to ask you how you mentioned when we were in the bar together that you were doing another event with Kath Jeffries. How did that Friday event go?
Oh, good. It was really good.
What was it? It was health people in Victoria?
Yeah, it's all health people. It was good. And we talked about psychosocial risk there as well, which I think, when what seems to be emerging is regulator action in big government, quasi-government institutions, health, education, university sector. There seems to be a bit of a pattern around that. We're not seeing a lot of the sorts of interventions we're going to talk about today aren't emerging yet in industry generally.
Well, that's interesting.
It is, but government's always a soft target for safety intervention.
Really?
Well, they're big, they're bureaucratic, they got lots of people, they got lots of process.
It's hard.
It's easy. Yeah, we'll come to it.
But it's easy to find problems. Is that what you mean?
I think so. And so, you look at, well, we'll come to it in the case, but you look at the volume, we're talking about incident investigations, and you look at the sheer volume of work that something like the New South Wales Department of Education has to deal with by way of internal investigation. There's going to be slippage.
Yeah. Well, we were thinking our ideas for Series 3, and welcome to Series 3, even though we kind of launched in the actual bar. This is our first kind of episode proper, so to speak, for Series 3. And the idea that we had was that we were going to try and focus in on getting guests who were implementing controls for particular hazards and how they were finding the implementation and the intersection and how they were developing those and particularly monitoring for effectiveness. But it also seems as though I think it's quite interesting that there does seem to be a few decisions coming through. So it may well be that we shift focus a little bit and do focus a little bit more on some of the clarity that's coming through around this reasonably practicable kind of idea from some decisions. So yeah, there's a lot. It's going to be a very, very interesting series, I think, with some interesting information coming through from some of the regulators and decision points. But here we go. I'm kind of keen, Greg, not keen, not the right word. I'm interested in the fact that this decision has come through, particularly as we create a bridge back to our Series 2 content and the reasonable management action deep dive that we did there in Series 2, because I think that a lot of that conversation is going to feel quite relevant as we talk through today's decision. Did you notice that as you were reading over the decision and reflecting on some of our previous conversations?
Perhaps a summary of the case might help to frame it before we dive into it.
Go.
This wasn't a case in the sense that it wasn't a prosecution, and it wasn't in particular an analysis of individual circumstances. It was a case where the New South Wales regulator had issued an improvement notice to the New South Wales Department of Investigation in the context of the department's, what did I say?
Investigation.
Well, when you look at the number of investigations they had going, you wonder if they were doing more investigating than educating. Issued improvement notices to the Department of Education about their investigation processes. And I suspect this is what caught your interest. But the notices weren't, so this wasn't, although they were triggered by particular individuals, an employee who was named A, who was issued with a notice, it was issued with a notice of a misconduct investigation in April 2023. They were assigned alternative duties. After receiving the notice, they attempted suicide, which wasn't successful. And so April 2023, and then in November 2023, the person who'd been issued with the misconduct allegations made a complaint to WorkSafe saying, I'm suffering psychosocial harm because of the length of time this has taken. That's kind of background. And the department issued notices saying that improvement notice basically means the department comes in, looks at what you're doing, issues a notice and says, you have to fix these things about the way that you're managing safety or a hazard or a risk. And the notices said that you have to basically ensure your investigations regarding misconduct and performance of workers are completed in a timely and expeditious manner. And you have to have regular documented updates on the progress of an investigation for your workers. And you have to have systematic process for risk assessing allocated alternative duties while an investigation is being undertaken. So in that sense, it relates to reasonable management action, but it wasn't, because it wasn't a conversation about the application of process to a specific individual and whether that was reasonable or not. It was a look at the system that said your system is not fit for purpose to manage psychosocial hazards because of the lack of time, effectively a lack of timeliness and a lack of rigor around decision-making for the allocation of alternative duties. And I'm going to get a little bit legally technical here, and this is this distinction between legal compliance and prevention of harm. It wasn't, I've got to make sure I've got the right case because I'm looking at two and I'll talk about the other one later. The court wasn't, in this case, concerned about whether a decision, for example, to allocate alternative duties was a good or bad decision. It was whether there was an appropriate process for making that assessment. So again, you've got process over outcome sort of conversations that come into it. Now, there was lots of there's lots of technical conversations in these cases about how improvement notices get reviewed. And so the first half of the decision, which I don't think we'll do much with today, is really about what are the principles for reviewing an improvement notice. But the second part of it was then this conversation about, fundamentally whether there was a justifiable, reasonable belief by the inspector the department was breaching its obligations because it hadn't properly addressed those concerns.
And for me, there are a couple of really important psychological impacts or harm impacts that really, really stood out to me in regards to this.
You have been.
That's probably why, and it's in terms of my, what would you call it? My level of passion around the importance, which I've said before, which is no surprise to anybody, about my level of conviction, I guess, about how important organisational justice as a hazard is, and how investigation processes as one of the key touch points for employees of an organisation's organisational justice. Because that's really how people, other than promotion is probably another one, preferences in terms of allocation of work, so those types of things come up quite a lot. But I think when there is a performance management or a complaint, they're the key touch points that people have into their organisation, into the organisation's justice systems and processes. In my career, I have spent a lot of time supporting people who are in those processes and have witnessed firsthand the harm, the very, very significant harm that can happen from them. And I don't want us to just gloss over the fact that this particular case, in terms of the psychological harm, was a catastrophic impact in terms of someone who did suicide. And that is the reality of when these processes hit people. This is not just a small possible psychological impact. And there were a couple of comments that were made by the Commissioner here in terms of, it being a very foreseeable risk in terms of the stress that is likely when people are involved in investigation processes, even if they're later innocent and later exonerated, was one of the statements. So I think for me, that's what I find so pleasing about this being this decision, is that it really does require organisations to go and fully reflect upon some key components of their system of managing this hazard.
I think it is, and you didn't need this decision, but I think it is beyond question that poor organisational justice or a lack of procedural fairness is a recognised form of psychosocial hazard. I think that's beyond question, and if you really want to track it down in the decision, it's paragraph 74. That's the submission that WorkSafe makes, and at paragraph 75, the Commission agrees with that, and I think that is clear and well stated and well understood. I think the more interesting distinction is the distinction between the known, foreseeable and recognised fact that people will suffer a degree of stress, anxiety as a consequence of any kind of investigative process, and whether and to what extent that process transfers from stress in a general sense to psychosocial harm in a breach of regulation sense. So when does it become an illness or injury that qualifies it? From a technical legal risk management perspective, the challenge is incident investigations are a known form of psychosocial hazard. As a PCBU, you must put in place measures to mitigate the risk of psychosocial harm arising from that hazard.
And that timeliness, and to me, we really do bring the language of the decision into the psychological process that is happening for the employee. Ultimately, timeliness of the investigation process is a critical factor in terms of the length of exposure and the length of time that a human being is sitting in intolerable amounts of uncertainty, scrutiny, and therefore very intense negative emotion, and therefore likelihood that will turn into harm.
Yeah. So, on the facts of the case, they're talking about 606 active investigations, 245 ongoing between 0 and 6 months, 191 7 to 12 months, 81 13 to 18 months, 43 18 to 24 months, and 46 investigations, over 2 years.
Over 2 years. And this is, I am going to sound pretty with high levels of conviction around this, and I don't want that for in any way to diminish the reality of, to your point, government agencies who sit with high volume, high expectation, a lot of bureaucracy inherent in those departments, and probably not the correct allocation of resources, right? But I'm also really, really mindful that my role in this podcast and these conversations is to help to draw out, well, what is the psychological mechanism? What is actually going on for the individual in these situations? And when you look at those numbers, it's like there is a human being in each of those situations sitting there, not really knowing what is going on with somebody with something that's happening with their performance or conduct for 2 years.
So there's at least three things that jump out to me as a lawyer who work in this area. One is, I think in the context of some of what is described in the decision, and particularly the number of stakeholders that the Department of Education has to engage in, and reading between the lines when they talk about the police, Office of Children's Guardian, there's obviously some very complicated investigations that the department is part of and maybe not even leading. So there's an issue there. There's a secondary issue that lots of the delay, and I'm not talking about blame, this is more of an apportionment, lots of the delay in some investigations is due to the conduct of the person being investigated. So they're off on leave, sick leave, workers' comp claim, they've got their own lawyer, they can't do anything but through the lawyer. So often, once the relationship breaks down slightly, delay almost becomes inevitable because the parties can't find a way to talk to each other. So and this is the whole, to me, we've talked about this as like grievance procedures. Once you hit the tripwire of a grievance procedure and you go into that formal adversarial process, I think that inevitably leads to a delay. But I'm interested that you pick on the 2-year time frame. So I had a client got served with a prosecution notice yesterday, and the regulator under WHS legislation has got 2 years to decide whether to commence a prosecution. So if you're an individual or a company, the owner of a company, and an incident's happened, you will not get it. And this was issued, so the deadline for the prosecution was, so it was a fatality on the 3rd of April 2024. Deadline is 3rd of April 2026, which this year happened to be Good Friday. It looks like the charges were filed that week. Looks like they were filed in time. We're just looking at it. Client doesn't get served until yesterday. So, you get to that 2-year time period and you think, have I been charged? Haven't I been charged? Regulator doesn't tell you. Regulator doesn't communicate with you at all during that investigation process. So everything that's criticised in here is embedded into the WorkSafe investigation process.
That technically those people could actually have some kind of claim back against the regulator in terms of the regulator's actual system of prosecution.
Well, it's not their system, it's what the legislation says. So I'm not sure you could.
Like, is that possible?
No, I wouldn't have thought so. Yeah, and so I deal with business managers who are stressed out of their mind, especially small business owners. They don't know if they're going to lose their business. They don't. I've got one where there's a realistic possibility of individual charges. So you've got people with that hanging over their heads for 2 years. No one's communicating with them. No one's talking to them. So.
But I am keen for us to explore this idea of I'm going to get the legal kind of positioning of this wrong, but there was a list of reasons that DOE submitted in terms of why delays occur in investigations. And on looking at that list, to me, a lot of the items on this list, I would have thought now employers would need to be putting some consideration into how they would manage these reasons in their system of work. So I thought that might be an interesting thing for us to talk through.
So what stands out for you from that?
Key one that stands out for me is about availability of witnesses, investigations, workplace behaviour investigations, because I would see that it is within an employer's control to create policies and procedures that would incentivize, encourage, ask employees who are on leave, for example, that in the broader system and in the broader sense of commitment to assisting the expedition of investigation, that there could be some kind of incentive or made to people who make themselves available while they're on leave to participate and to provide evidence. So that comes, and the reason I go to that one is because when I've talked about this, over my career, I've talked about this with my mates who are in employee relations or IR or responsible in the HR system for doing investigations. And when I get on my high horse about, come on, you guys, like it's just inhumane having people sitting not knowing what is going on for this amount of time. Like I find it really hard to get my head around. And then they say things like, well, Kate, sometimes people aren't available and all this kind of stuff. And I just think that this decision forces the norm of, well, someone's on leave, so we can't get them, to, well, hang on, actually what is within our remit to actually try to reduce the amount of time it takes to get a resolution on these things. And I think it also takes me back to that conversation that we've had a number of times on a case management, like doing an appraisal, doing an assessment up front of complexity, who's available, certainly having key performance indicators or service level agreements in place with your external providers who provide the investigation services, and creating a system of expectation to those providers in terms of, well, don't take this case on if you are so busy that you can't begin to interview people for another 3 weeks. That's all within an employer's control, in my view.
Some of the complexities around that, there's always nuance and you can always do better, but there's also always roadblocks. So some of the things that I've personally experienced trying to help employers in this scenario, when you have people who are all off on stress leave with medical certificates saying can't be contacted while on leave. And so you face a problem there of you've got a person suffering potential psychosocial harm from a delay in investigation and creating a whole new strand of psychosocial harm for a different individual by reaching out to them while they're on leave.
Well, I would put that in the same bucket that we've been dealing with for 40 years in terms of injury management processes, when a doctor's certificate says totally unfit to work, yet with the right people with the right expertise, qualification and approach can then contact doctors and talk through more broadly and help doctors to understand that there are alternate duties available, and how would this land? And you can, those things aren't written in stone. They require process and nuance around them to help educate the medical practitioner on, actually there are other people who, and even your patient, there is now a lot of evidence that supports there's a requirement on us. The quicker that we can actually move through this, but at the right pace and in the right way and with the right support, can we discuss what that looks like and what you think that looks like? All of that's possible.
And you are presuming a very high level of sophistication in an organisation to go and do that. And we know that doesn't exist in lots of cases. The other compounding factor that we often see is the person puts in a complaint, and then when they get interviewed, it turns out that the complaint is far wider and far broader than what they've originally articulated. And you end up trying to chase down all sorts of avenues. Yes, I think there are legitimate reasons why some investigations take longer than, when you look at it objectively, you don't understand why. I think there are things we could do to better manage investigations. And my biggest fear, when I was talking about this case with Renee, and she said, oh, great, now what we're going to do is get a whole bunch of people just whacking timeframes on investigations and smashing them out and doing all sorts of different harm, which is why I'll just digress now and then I'll let you get back to your list of things. The Killen case.
Yes.
I'm not going to tell you about it in much detail, but I just want to make this point because I think this matters. So the Killen decision, Killen, was referred to in the DOE decision, and we'll link both decisions to the podcast so people can see it. And it was the same sort of thing, delays in investigation, and it had to do with bullying and changing reporting lines. That was the other part of the note. It was the same thing, improvement notice, delays, and how do you adjust reporting lines when there's these sorts of allegations. And in this case, the respondent to the improvement notice has made arguments and said it's going to take us 12 months to rewrite our policies to comply with the notice. And the court in that case very helpfully said, I don't think any of the findings require you to change your extensive written policies to rectify the deficiencies. You just need to exercise sufficient control over your investigations. And basically, they're basically talking about having regular monitoring by selecting reviewers with capacity, by providing internal resources. So just manage your procedure well. You don't actually have to bullet point every single part of a process in response to a criticism, which is a long-standing criticism of mine of safety management. But I just want to make the point that management discretion is a perfectly legitimate way to manage these sorts of issues. Now, there's a deeper problem, of course, in that we don't give managers the training and expertise they need to exercise that discretion, which is why they all want the comfort blanket of the grievance or other procedure so they can just follow the timelines. But any good system of safety management, and in particular any reasonable system of psychosocial risk, absolutely requires the exercise of discretion.
Discretion and judgment, and developing a judgment and having heard, listened, acknowledged the complexity, the individual, and this is where the idiosyncratic piece comes through again, individual idiosyncratic response. I think in that second, in the Colleen case, was that the one? I'm getting confused now having read all of these, reading all of them, 2 whole cases. But when I was reading them on the plane yesterday, when I did a day trip up to Sydney, I was really conscious again of that intersection of you can have your enterprise process. You need to be looking at the nuance and the idiosyncratic response of the individual circumstance and therefore the individuals that are involved in these particular matters. And I think that at a practical level takes us back to the thing that we have talked about a lot, is that idea of advisory or case management or whatever it might look like practice for organisations, which is you need to have a way to get the right input, get the right advice from people who know what they're talking about to inform the next steps of the process. And if you then document that, document those decisions, document the whys that you've decided what you've decided, to me, that feels like a practical approach to the psychosocial risk management that people are being expected.
No, I think that's right. There's 2 points I also want to make on the Killen decision, then I'll come back to what you said. First of all, the Killen decision predates psychosocial regulation. Okay, so it's not the regulations. They haven't changed anything. So that's important.
Not new.
This is day one.
This is not new.
Day one. And the other thing, to your point, when you talked about service level agreements with providers, there's a really interesting analogy in the Killen case, because one of the arguments they said was that, well, this is beyond our control because we engaged an external person to do the investigation. And the court said, well, hang on, here's an analogy for you. If you outsource your payroll, does that mean you now have no responsibility for how you pay people? It says you still are expected to devote sufficient internal resources to monitor the correctness of that payroll provider, and enhanced internal resources in circumstances where there's a reasonable basis to believe that the internal provider is failing to provide the services as contracted. So in fact, your outsourcing of incident investigations puts a different onus on you to monitor the performance of what's occurring.
Absolutely. And this is where I've always been so, I think, confused by it almost has felt to me in conversations in the market about this very topical issue. I think that when this happens in organisations and people realise it's not great, but people haven't seemed to have a sense of agency about what to do about it, right? Which is what is just like, well, what are you supposed to do? Investigations take a lot of time. I've just never really understood it. Separate, notwithstanding all those other points that you make, because I think they are very legitimate and those are real. But when I have had such a body of work in my career supporting people where none of those things that you're talking about are actually the factors that are causing delays, and there's a human being just falling apart, grown men just falling apart in front of my eyes, because it is just unrealistic and inhumane to expect people to sit in these situations for the amount of time that they have been expected to sit in these situations. I've worked in a lot of different settings where there are KPIs and timelines around providing an assessment back to someone who needs the assessment completed in a timely manner. And that is the service level agreement that wherever I've worked has signed up. And so it is wherever I've worked's job, and often, then turned into my job to manage the resources to make sure that those services were being provided in the timely way at the same quality that we've committed to, and providing the outcomes that are needed to the system that we're operating within. And I've just not understood how that's not ever emerged in the investigation marketplace. And I think that this is probably going to be an important lever in organisations looking for providers who are prepared to sign up to those things.
Yeah. Part of me says yes. And again, this is what concerns me. And I think my concern is driven from my history in work health and safety, where everything is so binary. Because I've seen time and time and time again organisations that set internal timelines on incident investigations, and these are physical harm ones, right? Which, this within 24 hours, this within a week, and this within 14 days, right? And it just produces appalling results because we're not prepared. Listen, so that's technical, that's process.
People just being more focused on expeditiousness, I think that that's a really good outcome.
But I think there's a bigger question as to how many of these types of issues actually need to be investigated, and what are the alternative pathways to resolution that don't require this kind of, and I don't know why, all right? I don't know why people fall into this funnel of it's an investigation, therefore we have to treat it like some sort of judicial inquiry and witness statements and balance of probabilities and proofs. And there are better ways, there are better conversations, I think, that we can have to resolve some of these things, or at least to explore if they're resolvable early, rather than jumping straight into this kind of investigator, prosecutor, witness type of attitude.
So I remain confused about why there is so much confusion about this. When you're a lawyer, and not just any lawyer, a very highly qualified, high expertise in employee relations matters and workplace health and safety matters, when you say, I don't understand why organisations do this, yet when you speak to organisations, they say, well, that's because we legally have to do it and we need to comply. Why? Help me understand. Like, I don't understand how this, almost like we're in this gridlock. If I listen to you as someone who I trust for legal advice versus what I see in the market in terms of, and what, internal legal advisors are saying. And I take your point about small business. When you see this happening in big business and it gets so bogged down in systems and processes that you're kind of saying, I don't understand why everyone's doing this. Where's it falling down, and why is it falling down, and why is there so much confusion, do you think?
I'm not sure it's confusion. As to the why, I think I think the why is driven, unfortunately, by a very large degree by internal process. Greg, our process says this is what we have to do, so this is what we're going to do.
But if we take the segment of employer, like the big business section of the Australian corporate community, that does have access to legal advice and therefore does have access to review of policy and how it and process and how it helps or hinders the broader objectives of the organisation's workplace health and safety effectiveness. Why would that be happening? Like, why aren't other lawyers saying, why have you got all of this?
I think some are. There's also the reality, Kate, that we've done it this way for so long,
Right.
and there's a lot of sunk cost. Like, lots of organisations have invested lots of money in investigation training, investigation methodologies, databases for recording investigations, all of that sort of thing. If you suddenly said, well, we probably don't need to do 70% of these investigations, there's a different way to think about it, that's a bit problematic for me. And I'm not saying we need to discount all of this altogether, but all I'm saying is that surely we can have, and I can't see the legal risk of saying if parties are making grievances about the way they're being treated, either organisationally or between individuals. So, if they're saying, look, this investigation or this process is taking too long, why we can't engage in, I don't even know if mediation's the best process, but
Facilitated communication or somebody coming in and helping people talk to each other rather than an investigation.
some sort of facilitated process where we say, okay, what's really going on here? And if it is apparent through that kind of facilitated attempt to resolve the dispute that the dispute is not resolvable, then, okay, we know we can't resolve this wedge between the parties, so let's do it formally, and we'll pick the winner and we'll pick the loser and we'll see what happens. But I think the problem with our current processes around both psychosocial risk and a lot of our employment management stuff is we lose the opportunity for that because once we start the formal process, the wedge has already been created. So and I think it's very hard to recover from that.
So while we're on this train of thought, the nuance attached to conscious of the human relations kind of cohort of our listeners, not the safety people of listeners, because I think this one will get a lot of attention from human resource practitioners. This idea of if you know that somebody, like I was involved in a mock court event for the emergency services sector in Victoria last week. And in this mock court, I was playing the role of the Director of People and Culture, and I'd been given a script that I had to stick to make sure all the points were made, etc., for the audience. But one of the key things that was surfaced and was trying to be drawn out in that event was this idea of the manager knew that there was some underlying, probably would be deemed to be sexual harassment in an exchange between a manager and a staff member, yet they didn't take any action. And so in the context of the mock court for the prosecution, and it was a workplace health and safety prosecution, the point that was being made was that there wasn't a safe system of work to protect that worker from the hazard of sexual harassment. So if I listen to what you're saying now, are you saying that if at least there'd been a, hey, person Y, such and such has mentioned that there's been a little bit of, a few comments that they're not comfortable with. Actually, sorry, I take that back. I'm telling an absolutely incorrect story. The person wrote back to the manager and said, can we please only meet in work hours? And like they addressed it themselves, yet then there was retribution from the worker. So in that kind of situation, and the HR kind of people knew that that was going on, but nothing kind of happened in this mock court. Are you positing that a better approach would be, hey, let's actually just try and talk about it first before we go into was there sexual harassment or wasn't there, and doing a full-on investigation?
I think so. Now, I think everybody's terrified of that for the sorts of reasons you've kind of touched on in that conversation. Everybody's terrified that if they go and talk to somebody and say, hey, I've been speaking to Jim, he's a bit uncomfortable with some of the things you've been saying, I just want to have a chat to you about it, that you will get people saying, well, that's because everybody seems to take everything so personally. Right, I've got a grievance against him. If Jim's saying that about me, I want to lodge a grievance. I think everyone's terrified about that. I think with reasonably solid foundations, because I think that does happen a lot. I think that's why people don't speak up. I think that's why when managers see something that they're a bit uncomfortable about, it's much easier to say, "Oh, that's probably not what happened. I'm probably misreading that." So just the normal day-to-day conversations of the checking in, checking behaviors, setting expectations, just doesn't seem to happen very often in lots of workplaces. And so then we get to a point where somebody either is off on sick leave for stress and we need to investigate that, or they lodge a formal complaint and we need to go into that formal complaint process. So I think we miss a lot of opportunities along the way. And I'm not for 1 second suggesting that the systems of mediation, counselling or whatever are going to work in every situation and are not going to create problems of their own. But it does seem like a more logical escalation than to go from nothing to a quasi-internal royal commission.
Yeah. And this is where we get in, I think it was in our series 1 when we talked about conflict and the intrapersonal and the interpersonal, and how so much of this does get kind of connected back into an individual's own level or capacity to sit in the discomfort of, as well as capability to just raise something. And did that happen in their family? Did you ever kind of raise and talk about stuff and then you just move on and it's not a big deal? Like, a lot of these things are things that if they've never happened in a person's outside of work life, expecting that they're going to suddenly have the skills and capabilities to do it in an inside of work context is just unrealistic. And therefore, from a scalability perspective, in comes the process, in comes the bouncing ball, because we're trying to provide, with the best of intention probably, guidelines about what we want it to look like around here, because you can't just be adults, which is what you kind of hear people resort to, which would be nice if it was able to be that, but it kind of doesn't work.
So again, I mean, I swing back to some of our earliest conversations about this, Kate. I think the triage care team type model kind of makes sense. I think it does, yeah. Now, look, I'm not pretending for a second that any sort of interventionist, care-based, whatever model doesn't have to be backed up by at some point. If things don't work, you are going to end up in a formal process whereby you make decisions about blame and accountability and consequence. We end up with that. But as I've been talking about for a long while now, I think we simply need to build some more discretion into the start point of our processes to allow us the flexibility. And I think if we take the Killen decision, for example, we should look at that as an encouragement to say the courts recognise not everything has to be set out in a step-by-step procedure. There is room, and indeed more than being room, I think there is a need for that exercise of management discretion over a process. So the idea of saying investigations need to be done in a timely manner. Does that mean we need to put a mandated timeframe? No, it doesn't. Can it be a recommendation that says, initial views should be done within 14 days or some such nonsense? But there needs to be a discretion around it where people can make judgment calls. People have to monitor the investigations to know how long they're taking. That stuff just all has to happen.
And I do think back to how consultants operate, where you are asked to do an initial discovery, like you kind of, and it doesn't need to be a big deal. Like I used to do this all the time, particularly in the injury management kind of context, or you get briefed by an employer. Okay, I've got in my mind, as a professional who's worked in this space, a lot of questions and probably a bit of a structure to the questions that you would ask to gather some information to help you give an opinion about what would be kind of needed or what's the best approach at that point. And then you have marks along the way or points along the way where you get together again and you say, does this still feel right? Is there new news? Do we need to deviate? Do we need to bring somebody else in? Like, to me, that as we keep seeming as though we keep going back to this idea of case management that can integrate and be agile and shift as new news happens, as we see what people's responses are, that works, right? And it's tailored to the situation then.
So, but there's an underlying assumption there that the overarching objective is to ensure the well-being of people, as opposed to, can't we just get this solved so we can get on with things? And there's that frustration, particularly when you're dealing with allegations of harassment or misconduct, and there's stress claims involved and allegations of psychosocial harm involved and workers' comp involved, that frustration of process and desire just to get this thing resolved comes up super quick. And the mechanistic investigation, even when they take a long time, is often a very quick way to land on a position.
Yeah, so the conscience, one needs to have the voice of the conscience in these conversations around keeping the right balance or the right sense of judgment and discretion for the outcomes that are going work towards. But well, that was a good discussion. Lift our thoughts. What are your key takeouts, key advice that you would be giving to employers off the back of those couple of decisions that you've shared there, Greg?
Oh, I think probably for me there's two or three. One is you need to have better sense making around whether certain types of complaints or issues actually warrant investigations at all, or whether there's better mechanisms to deal with it. Secondly, recognise that the exercise of management discretion is a perfectly legitimate way to deal with these difficult claims. And the third one is you actually do need to exercise judgment in the way that you deal with people when there's been a complaint. And it is never going to be sufficient to simply follow process.
I would probably add to that the importance of getting the right advice from people who understand the complexity attached to humans and as well as the organisation. I think that getting the right, whether it's panels, whether it's finding someone who you trust, you like their values, you like the way they fit in your organisation, they work well with your people, get the right people around you for advisory in this space, I think is one point. I think the other point for me is about never underestimating the human impact, because it's real and they can end out in the catastrophic risk category very easily, unfortunately, when you don't necessarily know what else is happening in someone's life or what their psychological mechanisms and stresses and family, etc. are. So I think that is a really, really important one. And the other one for me is begin to engage with providers who understand this point around expeditiousness and listen to them about what they are doing to respond to this decision in particular. And don't just fall into this, well, because it's always been this way that investigations take a long time. Just look for the moments where there is agency that you can shift it along, because that is, to me, the key takeout from this is that there is an expectation that employers are looking for those things that create bottlenecks and are doing something about it.
Yeah. good points. Okay.
Well, great to chat, Greg. Thank you.
As always.
And stay tuned for the next episode where we will be either discussing another case, or I'm actually curious about getting somebody who does investigations out in the market in, Greg. I think that would be an
That'd be good.
interesting conversation. So I've got someone in mind for that. So
Okay.
have a great week, everyone, and thanks for listening.
See you, Kate. Bye, everyone.
That's a wrap for another episode of Judgmental. Thanks again to our sponsors, EML. EML's Mutual Benefits Program provides organisations with free services, tools and resources to manage their workplace risk. You can follow EML, myself and Greg on LinkedIn, and be sure to check the show notes for links to the papers referenced in each episode, as well as resources available to help you as you navigate the wonderfully complex and nuanced world of psychosocial risk. See you again next time at the bar.